there's really nothing worse than it being a hot summer day and the AC isn't working. And depending on where you live, air conditioning can be more of a necessity than anything else. Especially in very humid environments, the temperature can get so high that it becomes dangerous. So since air conditioning is so important, does that mean that property owners are responsible for providing it? Well, let's go over the tenant's rights to air conditioning and the landlord-tenant law regarding it so you can appropriately maintain your units. In most states, landlords actually are not required to provide air conditioning. This means that even if there is no air conditioning in the property, the tenant cannot withhold rent because it is considered just an amenity. The reason for this is that air conditioning is not considered a factor when defining the implied warranty of habitable living conditions. Some of the things that are considered necessary include working gas, heating, electric, and plumbing systems, non-leaking structures, no health hazards, garbage disposal, and much more. These are all essentially meant to protect the physical health and safety of the tenant. Note that a working air conditioning system is not included on that list, but there are many states where the landlord is responsible for providing air conditioning. Some of those states include Arizona, Florida, Kansas, and Nevada. In these states, the landlord is actually responsible for providing and maintaining the air conditioning in rental units. This is due to the extreme heat that the tenants and the rental units can suffer through in these states. So let's go over some general guidelines when it comes to AC on the rental property or submitting maintenance requests. First, know your state law. Since some states make it a landlord's responsibility to provide a functioning air conditioner, the tenant may want to include this in the agreement. However, if the state does not require the landlord to provide an air conditioner, the tenant might want to pay more attention. In these cases, the landlord can include in the lease that the air conditioning will not be provided in rental properties. This means that even if the existing air conditioning fails, it's not the landlord's responsibility. And in extreme cases where the heat materially affects the physical health and safety of an ordinary tenant, actions can be taken. In these cases, the tenant can demand the AC be fixed and can start withholding rent as the landlord is going against landlord-tenant law. The consumer protection departments of many states regularly modify landlord-tenant laws. For this reason, it is really important to keep up with them at all times. If you're not quite sure where to find specific laws for your state, I left a link down below to learn about every state's different landlord-tenant laws. The second general guideline when it comes to AC is disability accommodations. In some cases, your tenant will have a medical condition that will require them to have some sort of operational air conditioning. This is treated the same as a support animal as a reasonable accommodation. This could apply especially to areas of colder climates where people can get sick easily. Sometimes the landlord will be responsible for providing the tenant with heating systems like a portable AC unit or a window unit. Essentially any system that can provide heat. If the landlord has property management software or a property management company, the tenant may have to submit a work order. So now you know the basics, but I do have some tips on how to handle air conditioning maintenance and repairs. When the air conditioning in a rental unit breaks down, it is usually the landlord's responsibility to fix it. The landlord is also responsible for replacing, if needed, the entire system. If the system broke down due to something that the tenant does not control, like natural forces, the landlord is also responsible for covering all costs. However, if the air conditioner breaks down because of neglect by the tenant may be liable. So when the air conditioning breaks down due to tenant negligence, the landlord can choose to either have the tenant find a maintenance professional and cover the cost, or simply deduct the cost from their security deposit. On the other hand, when an air conditioner breaks due to anything else, the landlord has a specific time limit which they must repair it. For example, in Arizona, the landlord has 2 to 5 business days from when they receive the notice to fix or replace the unit. To save yourself time from any troubles regarding AC, there are some easy steps to follow. For example, the unit should be inspected regularly as a part of routine inspections. This way, any problems can be identified and fixed before they become worse. Also, depending on the state, the landlord could opt out of AC repairs in the written lease agreement. And when dealing with a broken AC or anything regarding a tenant, it's always really important to document everything. This is in case the dispute goes all the way to court, which landlords typically want to avoid. In the case of a court hearing, it's always best to have every communication with the tenant documented. For example, it is essential that you document when the first written notice of the AC problem was sent. This shows the court how much time the landlord has taken to fix the AC after the written notice. It's also a really good idea to become familiar with your lease agreement. Since the lease is essentially the governing document between the tenant and the landlord, it can either make or break a case. For example, if it's clearly written in the lease that the landlord will not be responsible for repairing the AC, it can be more difficult for the tenant to make a claim. So there you have it. I hope this video was able to kind of make that clearer for you and to describe the landlord-tenant laws. And if it did, make sure to give it a thumbs up and subscribe for more property management content. I'll see you in the next one. Bye!